Good evening, everyone. Welcome. I'm Harold Holzer, Director of Roosevelt House, and it's wonderful to welcome you here for a program we've been looking forward to for months for several reasons. First of all, issues like this, when we present them, are always imbued with the special, inspiring magic of Roosevelt House because of all of the social programs that were developed here and the social consciousness that was manifested here by both Franklin and Eleanor Roosevelt. So we always consider this the perfect spot to explore topics of moment and concern. And we couldn't have had a better guest in Chase Strangio, but I am not going to introduce Chase. I'm going to let Charlie do that. I'm going to devote my time here, not only to the welcome, but in, I guess, the first formal welcome of Charlie Kaiser as the Associate Director of the LGBT Center at Roosevelt House. I realized when we first started talking to Charlie that I've known him for 40 years. I met him. No, I'm going to tell the truth. I met him when he was a reporter for the New York Times, and I was working in the mayoral campaign of 1977, first for Bella Abzug and then for Mario Cuomo. And I got to drive you and who else around for campaign stops? Adam Nagurney. And both of them turned out not only to be very difficult reporters, but pioneer historians of the gay rights movement in New York. So we are so proud to have Charlie with us. And of course, as you know, is not only a veteran journalist with the Times, but the author of the brilliant book, The Gay Metropolis. He is going to add so much to the student experience and to faculty and to public events like this one, which is going to be his specialty. So please welcome Chase Strangio and Charles Kaiser.
Thank you very much, Harold, for that lovely introduction. And thank you to Jennifer Rabb. Jennifer and Harold are really the two reasons that I'm sitting here tonight, and I've had a wonderful experience at Hunter so far. And I'm very excited to have Chase Strangio here tonight because he is one of the most articulate spokesmen the ACLU can offer us. But before we get to that, I want to pay very brief tribute to Vincent Scully, the great architectural historian who just died at the age of 97 and was probably one of the most popular professors anywhere of the last 50 years. And although he is known for his architectural criticism, in 1995 he gave the Jefferson Lecture and said something which I think is very important. Ours is a time which, with all its agonies, has been marked most of all by liberation. In the Jefferson Lecture of 1995, the architecture of community, Scully declared, I think especially of the three great movements of liberation which have marked the past generation: black liberation, women's liberation, gay liberation. Each one of those movements liberated all of us, all the rest of us, from stereotypical ways of thinking which had imprisoned us and confined us for hundreds of years. Those movements, though they have a deep past in American history, were almost inconceivable just before they occurred. Then, all of a sudden, in the 1960s, they burst out together, changing all of us. Well, it's certainly true that the gay movement burst out practically from nowhere in 1969. The black movement, of course, had many other antecedents, including the abolitionist movement, and the women's movement had many antecedents, including the suffragettes. But the gay movement really had almost no antecedents at all. There was something called the Mattachine Society in 1951 in Los Angeles, which I'm sure 3 or 4 straight people were aware of. And in the 1950s, there was James Baldwin, who very courageously came out, even though his second novel was turned down by his original publisher because it had a gay theme. And there was Allen Ginsberg, and there was sort of Gore Vidal, although he would never describe himself as gay, only someone who participated in gay acts. But because of the black movement, the gay movement really takes off with extreme speed after the Stonewall Riot of 1969, and that's because the black movement had really given us a very explicit blueprint for everything that we would do. And one of the things that we have had in common with the black movement, which had such great legal minds as Thurgood Marshall, is that we have also been the beneficiary of tremendous legal minds, beginning with my great friend Tom Stoddard, who is no longer with us, one of the first people to die of AIDS at the age of 48, but who from 1986 to 1992 was the director of the Lambda Legal Defense Fund. And in 1993, he led, believe it or not, think of this, in 1993, the first delegation of gay activists to meet in the Oval Office with the president, Bill Clinton. Of course, it was an ultimately unsuccessful effort because Tom at that point was leading the fight to make Bill Clinton live up to his campaign pledge to let gays into the military. But nevertheless, the Clinton administration was a big leap forward, partly because it appointed so many openly gay people, of which there had been none. In 1953, of course, Dwight Eisenhower had signed an executive order which banned gay people from all federal agencies and all federal contractors, and not even the ACLU challenged that order at the time, although it would get around to doing so later on. Chase is part of the LGBT project at the ACLU. He's been there for 5 years, and he's already been on some of the most important cases, including the North Carolina bathroom case and the challenge to the Pentagon for the transgender ban, which was, of course, announced in a tweet by our president. And he's going to talk about first how he came to file this suit against the Pentagon and where we stand today in this battle.
Well, excuse me. Thank you so much for having me here and for that introduction. It is a little bit disturbing to sit in this space, as incredible as it is, where, as was mentioned, so many social programs were thought up as we seem to be on the verge of abolishing them all. But I want to draw from that to sort of really think through this historical moment that we're in and how we can sort of leverage our role as advocates, as activists, and as lawyers to ensure that we're laying the groundwork for a future that doesn't include the types of repressive actions that we're seeing right now every single day. And so to speak to that, we spent a long time working during the Obama administration to get rid of what had been a ban on transgender individuals serving in the military. So when Don't Ask, Don't Tell was repealed, it left intact a ban on trans people serving in the military, classifying trans people as administratively unfit to serve. And of course, there were trans people serving. We know that. We spoke with them. They existed. But they couldn't do so openly, much like gay, lesbian, and bisexual people during Don't Ask, Don't Tell. And we spent years preparing litigation and then doing advocacy with the Department of Defense, and were successful in 2016 when then Secretary of Defense Ash Carter announced the ban on open trans service. And so that got rid of the ban, and so trans people could then serve openly in the military. Then fast forward to the world in which we're in today, in which all these civil rights organizations had taken things off of their strategic plans, had checked off boxes, had ended programs, thinking that we had made progress. And there were lots of things on our radar to be concerned about when Trump took office. But in all honesty, the ban on trans service, despite it being a priority of the Family Research Council and some very far-right organizations, it was not the thing that we were the most focused on. And frankly, it didn't seem to be the thing that the Department of Defense was particularly focused on either. And what happened was Congress in the House, they had proposed an amendment legislatively to ban funding for medical care for individuals who are transgender serving in the military. And that amendment to to an appropriations bill was actually defeated in the House. And so that was an incredible accomplishment in a very conservative body of Congress. And the sort of evangelical forces who have at least the vice president's ear in the White House were very upset about this. And so, it's July, and all of a sudden we're heading into work, and one morning the president tweets off 3 tweets, essentially saying not only are the Defense Department and the executive branch going to take action to bar coverage for medical care for trans people, but that all of a sudden trans people cannot serve in the military in any capacity. So this is July of this year. Secretary of Defense Mattis is on vacation. It's very unclear where this is coming from, but it's the president's Twitter account, which we know is the official word of our government at this point. And so we started to scramble, and of course the thousands of trans people serving in the military all of a sudden in an instant have their entire lives uprooted. The possibility of the years of service that they've put in being completely undone, losing their pensions, losing everything that they had worked for. And so the LGBT movement really did sort of have this moment of reckoning, again, realizing, wow, we really are moving so far backwards. But at this point, it was just a series of tweets, and the defense secretary is on vacation. As far as we know, the Joint Chiefs are saying they have no idea what's going on. Everyone's publicly shocked, including...
And they're saying that after Trump has pretended that he's consulted with them.
Yes, after consultation with my generals, that's what the tweet says. And by generals, of course, he means Tony Perkins and the Family Research Council. He tweets these out, but of course we know that there's more formal guidance coming. And so at the end of August, they issue a series of directives doing precisely what the tweets say: banning coverage for surgical care for trans individuals who are serving, barring enlistments of people who are openly transgender, and indicating that people will be subject to separation just because they're transgender. And so, of course, we're not happy with this action. It's patently unconstitutional, and a series of lawsuits are filed, including one by the ACLU, arguing that this violates the Constitution and the equal protection and due process rights of transgender individuals. And at this point, there have been 2 courts that have struck down the ban via preliminary injunction. So essentially, at the first stage of litigation, putting the ban on hold, saying it's likely that you will succeed. And as this case moves through the courts, the federal government cannot enforce the ban.
How many cases are there altogether? There's more than 2, right?
There's 4.
Right.
So now there's 4. One has sort of been put on hold because of the 2 preliminary injunctions, and the third case is a case from Lambda Legal that was filed in the District of Washington, and that had a hearing, and the judge indicated that she would rule by December 8th, which is this Friday. So I anticipate that we will have 3 separate courts enjoining the ban.
And your case is in Baltimore, right?
Our case is in Baltimore.
And the judge was it was pretty much of a complete victory for your side, wasn't it?
It was. The judge was not impressed with the president's thought process. And often in the courts, there is a significant amount of deference that the courts usually afford to military decision-making, issues pertaining to national security. And the judge essentially said that it's very clear that deference is not owed in this case, because deference only comes when it's the product of the deliberative process that the Defense Department goes through, and it's very clear that the 3 tweets from July did not reflect that. And in the preliminary injunction stage, you can put in hearsay, so you can put in things like newspaper articles, and so we had a ton of articles, including the many that quoted Secretary of Defense Mattis saying that he was on vacation and didn't know this was happening, which certainly undermined his argument that he consulted his generals. And we also had the president himself saying in media interviews that he did the military a great favor by just cutting to the chase and getting rid of trans people in the military. So again, he was essentially telegraphing the lack of thought, the lack of rational basis that went into this process, which did make it somewhat easier to challenge in court than what you're used to. It used to be that you would say as a lawyer, oh, it's so hard to prove intent, and you have to go through extensive discovery. But with this president, he usually telegraphs his intent on Twitter, and the Department of Justice then scrambles to try to argue that something else happened.
And surely the long and successful battle to change the policy from Don't Ask, Don't Tell to what we have, and the fact that when the policy went into effect, it seemed to be one of the great non-events in the history of the Pentagon in terms of the reaction of the rest of the forces. And surely that has contributed to the atmosphere, which has produced already two good decisions, don't you think?
I do. I mean, you can't discount the work that the movement did in the context of sexual orientation-related advocacy, in the marriage context, in the context of Don't Ask, Don't Tell, to start to destabilize the norms and the concerns and stereotypes that people had about gender across the board, which then laid the groundwork for the trans movement. Now, I don't want to give too much credit to the LGBT advocacy because I think trans people were very much left behind and there was a lot more that needed to be done. But I don't think it would be disingenuous to say it had no effect. It definitely did. And then the more openly LGBT people you had in the military, the more, just like when you had integration of the racial integration of the military, just like increasing roles for women in the military, obviously this changes the nature of the culture. And my brother was in the Army at the time that Don't Ask, Don't Tell was repealed, and definitely indicated that it was essentially a non-event. That said, I do think it took a lot more years to get the ban on trans service overturned. There's still a lot more work to changing the public consciousness about what it means to be trans, and even the fact that the president felt emboldened as he did, and that there are still forces in state legislatures every day trying to really eradicate trans people from existence. I think there's a lot more work to be done, and more work that could have been done in the years that we were doing the Don't Ask, Don't Tell, the marriage, and the other advocacy on behalf of the LGBT community.
Are you the first trans person to be a lawyer with the ACLU LGBT project, or were there others before you?
Well, that's a good question. I am that I know of. The first staff lawyer with the national office, I believe.
And did you have to do a lot of educating, even of ACLU lawyers and even of gay ACLU lawyers, about these issues?
We're being recorded. Yeah, I think, I think progressive organizations can be some of the most, insidious in certain ways when it comes to racism, when it comes to gender-based discrimination, when it comes to discrimination against LGBT people. We have an idea of ourselves as progressives, and that can sort of make us complacent. And I think when it came to the LGBT movement, it's an incredibly white movement. It's an incredibly male-dominated movement. There's very few trans people in leadership, and so there's a lot of internal work that we are continuing to have to do. And certainly, when I came into the organization, there were a lot of growing edges. I was unhappy with the healthcare situation, the bathroom situation. So we have to do our own. We have to clean our own house, so to speak. And I think that there remains a lot of work for all of us in the LGBT movement to continue to challenge ourselves, to look at the biases that have been entrenched over time, that have put, in leadership, very few trans people, very few Black people, very few people of color in general. And that really is part of our prerogative right now, as we're all under attack, to really be, showing up for justice for everyone, and that means including in our movement, really building up the leadership of the people who have historically not had as much of a voice. And when I started at the ACLU, I was hired in 2012 and started at the beginning of 2013. It was the first time in state legislatures that we started to see this wave of anti-trans bathroom bills. And I remember, we were still at the phase in the movement where people were very afraid to talk about trans issues in the media. So the message was, okay, we can file these cases, but we don't want to talk about trans people going to the bathroom because that will really freak people out. And I was like, will it? And I was like, I don't know how far we can get if we're not really able to acknowledge our full humanity. And so I think it took a lot of time to really, as a movement, say we're going to have to put actual trans human beings out there, even ones that go to the bathroom, and sort of deal with our full humanity. And so that's been a real shift in the last 5 years, I think.
And does it affect your work, that the fact that you are trans yourself? Do you do anything to make it clear to a judge that you're part of this group, or do you not, are you silent on the subject? How does that work?
So I do make it clear that I'm trans in most of my work, and that has sort of changed over time. I mean, first of all, I look trans to people, and so whatever that means, I'm aware of it. I like it. I'm not ashamed of it, and so there's that. I mean, I certainly don't hide it, and I'm really public about it. That's definitely true in the communications and public education work that I do, because I have found that it is really important, as we're building this movement, to tell our personal stories, to make sure that the narratives of our lives are central in the advocacy that we're doing. And so, especially in 2016, after the Obergefell decision striking down the remaining bans on marriage equality, and then the backlash in the state legislatures targeting especially trans people that year, I made a decision, and in the age of the internet, I mean, once you put it out there, that ship has sailed. But I made a decision that I was lobbying in South Dakota, I was lobbying in Tennessee, that I was going to put myself out there in every way possible, that I was watching these state legislators target trans young people in schools, and I just could not have it anymore. And it's hard. I have so much access and so much power and so much privilege. I'm a lawyer, I'm white, I live in New York City, I can visit Tennessee, but I'm not staying there. And so I could go and I could show up and I could say, listen, if I was in your state, and you did this when I was young, I may not have survived. And and what you're doing is setting kids up not only to suffer and face discrimination, but possibly be killed by other people or by suicide. And so that was in 2016, especially in the wake of marriage and the legislative sessions in 2016 and 2017 in the states. Before Donald Trump was president, we saw so much hostility towards trans people, and so I really did center my personal story. When it comes to judges and courts, it's a lot more difficult to make that decision, because I don't ever want to jeopardize the success and the advocacy of my client in the courtroom. Now, what judges think, I don't know. And on some level, you want them to know that trans people exist. When Gavin
and that they're apparently very intelligent and articulate.
And they can, yes, and they go to law school. And actually, when Gavin Grimm's case, which was the case of the transgender young person in high school in Virginia, and we took his case up to the Supreme Court, and it was ultimately sent back after the election, which we can talk about for a number of procedural reasons. But one of the big strategies was to educate the justices, especially our friend Justice Kennedy, about who trans people are, what it means. And so when we were thinking about the amicus briefs that we were going to present to the court, one of the briefs that we put in was just voices of trans people, lawyers, doctors, scientists, and we wanted to say very clearly, like, there are trans lawyers that are part of the Supreme Court bar that have appeared, not argued before you necessarily that we know of when they were out as trans, but that have appeared in this court, because that does make a difference. It's sort of, saying we're part of the world that you can imagine. Now, I don't love that strategy always, because it, sort of, you don't want to over-rely on it because it excludes so many people, and it sort of reeks of things like the respectability politics that we hear, and so many people will never be able to fit in sort of the Justice Kennedy marriage is the most important thing in the world narrative, but it's also important to deploy that when you can. And so it's sort of walking that line between telling your story and deploying your identity when you know it can move the conversation forward, but also knowing that the same biases that are directed towards your clients can be directed towards you, and you don't want to undermine your advocacy. So you have to be really careful about how and when.
And how did you become one of Chelsea Manning's lawyers?
So for those of you who are unfamiliar with Chelsea Manning, which maybe is not many of you, but Chelsea Manning was arrested in 2010 for turning over documents, in the public interest to WikiLeaks, which was a very different organization, I will note, at the time. And she was charged with a number of crimes under the Espionage Act and other federal laws. And at the time, she had just started to come out to herself as trans, and there was sort of always the specter of her transness in her court-martial. When she was arrested in 2010, I was working at an organization called the Sylvia Rivera Law Project here in New York City, and we started to get press calls about Chelsea's transness. And sort of the narrative at that time that people were sort of playing around with was she did this because she was trans. And that was never a huge part of the court-martial, and it never really permeated the public consciousness. She was out as a gay man at the time.
Do you think it had anything to do with why she did it?
I mean, I think who we are gives us the principles and the empathy that we have. So, I don't think she did it because she's trans. Did her transness give her, cause her to join the military in the first place? Possibly. She was homeless. She couldn't afford college. She was completely struggling with her gender and wanted to enforce norms of masculinity, which is why you see overrepresentation of trans people in the military, both on the trans masculine and trans feminine side. And she was...
What is our best guess of how many trans people are in the military, or is it just really not knowable?
Well, it is... I mean, I think it's not knowable because there's so many reasons why people don't want to identify themselves as trans, especially now. But I would, I think the estimates are in active duty in the reserves in the sort of 14,000 or more range. And then, there's lower estimates in the 4,000 to 5,000 range, but I think those are wrong. And so Chelsea, I don't think this is why she did it at all. I think, though, that the fact that she was trans gave her perspective on the world. I think it gave her some empathy, and when she saw what she saw in Iraq, she, for a number of reasons, decided to turn over these documents to WikiLeaks. Now, fast forward to 2013, she's convicted, and then she is sentenced on August 21st.
Are you her lawyer by this time?
No,
or not
so
yet?
she's convicted in August. In the interim, she has spent a significant period of time in solitary confinement at Quantico, and the ACLU has worked with her and her defense lawyer at various points. So the ACLU already has a relationship with Chelsea. The day of her sentencing, I had a feeling that it was only a matter of time before she would publicly come out as trans, just knowing the record in her case and sort of what she had disclosed up to that point. And so I reached out to the people at the ACLU who had been working with her lawyers in the past. And then the next morning she came out via a letter on the Today Show, and we had already started talking with, we had already had a relationship with her, at the time, defense lawyer David Coombs. And so David and I began speaking, and then Chelsea had a lot of faith in the justice system, even after those 35 years, and a lot of faith in the military to provide her health care, and didn't think a lawsuit would be necessary. Unfortunately, she was wrong, and we did ultimately have to sue them. So I started working with her the day she was sentenced, or the day after she was sentenced in August.
Did she have the operation while she was in the military? Well,
So in terms of what we sort of publicly know about Chelsea's healthcare and what I feel comfortable talking about is that she had, at the time of her sentencing, indicated that she wanted to begin hormone therapy, and the military said under no circumstances will we provide this treatment. Again, a somewhat shocking public statement, given even, at 2013, the law is pretty clear in the courts that bans on treatment for trans people violates the Constitution.
That had already been litigated?
That has already been litigated, and actually, I think it's really important to note this, which is that so we were ultimately successful in getting Chelsea access to hormones, and the reason for that, and the reason why we're so successful getting people access to hormones when we advocate for them or litigate on their behalf, is because of the mostly trans women of color who litigated cases pro se over the decades in the 80s and 90s and early 2000s, establishing precedent in most circuits saying that bans on
These
health.
were members of the military who did
No,
this
this
before?
is in just in the prison context. So the
Oh, in the
so the
prison
Eighth
context.
Amendment.
Oh, so the constitutional law was based on people.
on the civilian prison.
Right,
so
right,
so
right.
military prisoners are subject to the same
Right,
constitutional
right.
standards, and so the
So
Eighth
there hasn't
Amendment.
been any soldier who
No,
drank
so
them.
the military's position was, well, we've never had a trans person in our
Right, of
military
course.
prisons, and therefore we don't know what we're doing, so we're just going to violate the Constitution. And so we sued them, and we never got a decision in that case. We settled on the hormones. We continue to litigate their refusal to allow Chelsea to follow the grooming standards. So she had her hair cut every 2 weeks, and so we litigated over that. But her sentence was commuted by President Obama right before he left office, and so that case was mooted out by her release, which was a good thing.
And how surprised were we when Obama did that?
We were very surprised. So Chelsea had sent a petition for a commutation to the president in November, shortly after the election, and it, of course, there was always a hope that it would work, but it was considered to be quite a long shot, and the first sense that anyone on her legal team had that this was even within the realm of possibility was the week before, the Wednesday before President Obama announced the commutation on January 17th, when Cynthia McFadden at NBC broke a story that morning that Chelsea Manning was on the quote-unquote short list for a commutation. Now, there's no such thing as a short list for commutation as far as we know, and I remember I was at home getting my kid ready for school, and I'm reading Twitter like a good parent, and I see this announcement, and I was really shocked because it seemed very legitimate, and I was reading the article, and so I emailed the Chelsea's defense lawyers and the folks who we had been working on a whole campaign on her behalf, and I was like, did anyone know about this? And nobody had, and so at that point, we considered this a trial balloon, and that we went into full gear of, well, we have to let President Obama know that this would be the very best thing that he could ever do and get the message out. And so we spent, every waking hour from that Wednesday until the commutation, which was the Tuesday after Martin Luther King weekend, as we're all sort of gearing up for inauguration, just reinforcing this and appealing to his legacy on LGBT rights.
How exactly did you do that? Through public statements, or how did you do that?
It was a combination of a public campaign on Chelsea's behalf, contacts within the Department of Justice and the White House, a letter from every major LGBT organization that we could get to sign on, saying that your commitment to trans rights has been an incredible part of your legacy, and letting Chelsea Manning die in prison would be an awful, taint on that.
And is this the one good thing that may have been affected in a good way by the election of Donald Trump? Did Donald Trump's election, do you think, make Obama more open to the idea of pardoning her?
Well, commuting her.
Commuting her, excuse
because
me.
Joe
Excuse
Arpaio
me,
was pardoned,
commuting.
but Chelsea Manning
Right,
was commuted.
right.
I don't imagine that there would have been a commutation had Hillary Clinton won. I think this was perhaps, yes, one of the very, I don't even know, as the world collapses around us.
Because of
I don't know how to talk about this. But to the extent there was a causal connection, it was a good thing. I mean, I do really believe, Chelsea Manning had attempted suicide twice in the months leading up to the election. I don't think that she was going to survive her 35-year sentence, certainly not in a Trump administration. We had a DOJ that was supportive of trans rights, and we couldn't get them to take a decent position in her case. And so this was going to be a really long, uncertain battle on her behalf. And that was the message to President Obama in those final days. And now, who knows what happened? You know, I heard that like Malia walked down the hall and said, "Hey, Dad, you should do this." I heard all sorts of things, and maybe we'll never know. But it was, I will never forget, on the Friday before Martin Luther King weekend, Josh Earnest, who was then press secretary, got out to give one of the final press briefings, perhaps the final one, or certainly the last Friday one, and he had refused to comment earlier in the week, and then that Friday he was clearly testing out some talking points about the differences between Chelsea and Ed Snowden, and the reason why a commutation might be coming. And I was working late that Friday, and it was like really late, and I was just watching it over and over on the train ride home, and I was like, he's gonna do this. You know, I was like, he really is gonna do this, and it was. That weekend was unbearable, and we were getting all these calls about things, you know, oh, it's going to happen, oh, it's not going to happen, no, actually nobody has any idea. And then Tuesday, you know, and the ACLU was working on a lot of commutation and pardon applications, and one of the big things that we were urging, you know, we wanted sort of blanket commutations for certain, you know, prisoners who had been serving sentences for drug convictions. He did not do a lot of the things that we wanted him to do. And as bad as things are now, like, and as much as we're glorifying past presidents, including George W. Bush, I have a lot of concerns with President Obama and the doors that he opened in the executive to where we are today. That said, it was, you know, one of the most amazing moments of my career. It was shocking, and it was, you know, to get that news from Charlie Savage of the New York Times, the late in that Tuesday afternoon, there was a documentary being filmed, so I'm actually filmed while I'm finding out, and I just am swearing the entire time on the phone with Katie Couric, randomly enough. So that's how that happened, and then now she's out.
We'll take your questions, but one more thing we have to cover, since we have such a good expert on the whole subject, is a very important case that's going to be argued in the Supreme Court tomorrow morning. Tell us a little bit about Masterpiece Cake.
Yes, the cake case, or as I like to call it, the I really wanted to discriminate against LGBT people case. Tomorrow morning, the ACLU legal director, David Cole, will be arguing at the Supreme Court in a case that comes out of Colorado. Colorado, as you may remember from Romer v. Evans, has a non-discrimination law.
Yeah, it's ironic that our first great victory was a result of Colorado, and now we're back to Colorado again.
Yes, the first one was because Colorado did something bad.
Right.
This time is because Colorado did something good, which is Colorado includes within prohibitions on discrimination in places of public accommodation, which include, incidentally, bakeries, that you can't discriminate based on sexual orientation. And a same-sex couple who was planning their wedding went to a bakery. They were there for approximately 3 minutes, and they had gone with there was two men, one of the guy's mothers, to order a cake, and the bakery indicated that they do not bake cakes for same-sex unions. The Colorado Commission on Human Rights found that this was discrimination. The middle appellate court in Colorado agreed and upheld that decision. And actually, the Colorado Supreme Court denied review. So this is a case that went right from the Middle Appeals Court of Colorado to the United States Supreme Court, and the bakery is arguing.
So it was appealed by the bakery, presumably.
It was appealed. So like the U.S. Supreme Court, the Colorado State Supreme Court has a petition process. They don't take all appeals. They denied review, essentially letting the appeals court decision stand. And then they sought cert in the U.S. Supreme Court, arguing essentially a two-pronged First Amendment right to discriminate against against LGBT people. The first part of their argument, which they were more focused on in the state court, was that it violated their free exercise of religion. That has been significantly diminished at the Supreme Court, and they are much more focused, as you can tell from the media, on the First Amendment expressive right, that cake is art, and therefore, and that very well may be true. It's just that it's not true legally, that there's a constitutional First Amendment right to be exempt from generally applicable laws that are neutrally applied. So they are arguing in a variety of ways, trying to get a closer level of review at the Supreme Court. But the public messaging and the public narrative about the case has been really concerning, because it's been really, the baker has been cast in this very sympathetic light as a small businessman, and he's just, he just has these principles. But the principle at stake in this case is a huge one, with impacts that could reach, well beyond the context of, wedding baked goods and flower arrangements into, not just discrimination against LGBT people, but discrimination against particularly religious minorities and people of color, and could open the door to really undermining non-discrimination laws in general, which is, of course, what they want to do. And they also want to eradicate LGBT people from the face of the earth, and that's that is transparently clear. I joke about it often, but there is a very well-funded movement that is bringing these cases strategically. This was the petition in this case was brought by the individuals who are discriminated against, but the litigation is being funded, very aggressively by the groups that are pushing legislation in the states, that are filing cases on behalf of non-trans students, arguing constitutional violations just by sharing space with trans people. So this is a very well-coordinated movement, and the implications of this decision, are huge.
All right, we will take your questions with two provisos. First, we want questions and not statements. And second, please wait for the microphone to arrive. Madame, wait for the microphone.
Make this as a question?
Yes, it has to be a question.
Okay, this is my question. Who here has noted the bathroom situation in Roosevelt House?
I have not gone to the bathroom. So to answer your question, not me.
Okay, so can I make a statement now, Charles?
Okay.
There is no gender-neutral bathroom in Roosevelt House.
Actually, I think on the second floor there are several in other
Not
places.
here.
Just not on this floor, but on
Not
other
this floor.
floors there
Yeah,
aren't.
I'm
I
just
just used one of the gender-neutral
Yeah.
ones myself.
Anyway.
So.
It's just an ongoing, very upsetting.
And I will say that as much as in litigation we're arguing that trans people should be allowed to enter the binary segregated restrooms that accord with our genders, that access to, having all gender neutral restrooms is incredibly important, and just given how much violence and trauma people have experienced in the restroom, opening more all gender spaces it goes a long way. So thank you for noting that. And I will note that the ACLU only had one gender neutral bathroom for a very long time, but we have now opened more.
In the back.
So I have a question about the two cadets from the Air Force Academy and West Point who have been denied their commissions. Will they have to wait until the guidance is supposed to come out in March? Is the ACLU doing anything to help to support those two cadets? Do you know anything about it?
So I've read news articles about cadets. The cadets, and I think I'm not sure if any of them are represented in any of the ongoing litigation. The status now the commissions are technically enlistments, and so what happened was the Open Service Directive that Carter issued in 2016 had immediately changed the policy with respect to retention, so people currently serving, and then had delayed a year for training and implementation the enlistment provisions until July of 2017. Then when Secretary of Defense Mattis came in after the election, he further delayed the enlistment of trans people to January 1, 2018. So no matter what, January 1 was going to be the date for officer commissions and new enlistments. And the status on the enlistment piece is a little complicated because that decision by Mattis had happened independent of the tweets by President Trump. But the DC court that enjoined the directive in the first instance, so the first court to rule, has since clarified that January 1 remains the date for enlistments. And so to the extent that the Department of Defense is planning to try to delay the enlistments and commission as officers of trans people beyond January 1, that will violate the DC court order. So that will help people. Now, I will say one more piece about the Open Service Directive, which is that it was not perfect, and actually the enlistment provision is incredibly onerous. So a lot of cadets in the service branch academies and people who are planning to enlist were still subject to significant delay under the Carter Open Service Directive because it required that people quote unquote complete all medical care 18 months prior to enlistment, which is a really hard standard for people to meet, especially people who are younger, given how difficult it is across the board to access healthcare. So people, I think people are working to ensure that people who want to enlist and commission are able to. January 1, 2018 is now the current date.
Questions? All the way in the back.
Hi, Chase. Is it on? Yes. Okay. I just want to say thank you for your work. I was a social media intern at the ACLU National this summer, so when the trans military tweets were announced, I was helping the team, monitor. My question is, how do you think, whether positively or negatively, does social media hinder or help in terms of litigation and fighting back against what seems to be a very doomsday-esque landscape we find ourselves in?
Well, thank you for interning with us. And one of my favorite moments from that day was when my coworker Josh Block was wearing shorts and a t-shirt, and we both had to do television interviews, and he borrowed a jacket and a shirt and tie, but he was still wearing his shorts. So we have a picture of him that the ACLU posted doing a television interview looking amazing. And so thank you if you had anything to do with that. But I personally really do believe in social media. I believe in traditional media. I don't believe that we can win exclusively in the courts. I believe in building power in our communities, and to do that, we have to be engaged on every front possible. So when I joined the ACLU, I did not know how to use Twitter. The ACLU encouraged me to get a Twitter account, which I'm sure they're regretting every day.
What's your handle?
It's just at Chase Strangio. And you will find my criticism of our decision making around some of our cases. And I worked on a case, before years ago, involving a Black trans woman in Phoenix, Arizona, who was profiled and arrested by law enforcement, and we challenged the conviction on constitutional grounds and other grounds related to the nature of what the evidence presented against her at her trial. But it was the first time I ever used Twitter to build a campaign and use a hashtag, and it was incredibly effective. We turned people out, and it really turned me on to social media as part of our litigation strategy, as part of our movement strategy, and I don't think I could do my work as effectively without it. And I also am frankly quite pleased, despite the fact that he seems to be instigating nuclear war with his Twitter account, I do think that the president's access to Twitter has been very helpful in our litigation as well. I mean,
Because he hangs himself every other day.
Well, but we now screenshot his tweets in our complaints, and the courts now screenshot his tweets in their opinions. And so it's a really different world. And but all joking aside, I think that that with all the problems with social media, and there are many, it's hard to regulate, it's hard to control harassment, it's hard to control very serious threats of violence. I do think it has sort of democratized access to, participation and conversations, and especially for people who are so disempowered when it comes to being out in the world, and the trans community is, chief among them, or at least, central among them. Access to the internet and social media engagement has been incredibly effective. And when you think about states too, where we're doing lobbying, and this is just my pitch too, as we are so focused on the federal government, we should never lose sight of what's going on in the states, because the blueprint for what we're seeing, the gerrymandering that led to the federal, the nature of sort of the repression of voting rights, and what we're seeing, paying attention to state legislatures is incredibly important.
And the other side has paid a gigantic
Yeah.
amount of attention, and we have never paid enough attention to
And
it,
yeah, I mean,
ever.
in North Carolina is a perfect example of
Yeah.
where this happened, where it was a blue state and it totally flipped to a red state, and it was very strategic, and we have to be careful. And when we're doing the work in the states, and there's a lot of states that are geographically very large, population-wise very dispersed, social media is an incredibly effective tool to mobilize people and to connect people who otherwise aren't just like walking into the LGBT center in New York City. And so I think it's essential for our lobbying work in states like South Dakota and Tennessee, Texas, where we do need to mobilize quickly, but we don't have the same access to the consolidation of physical space that we do here in New York.
We have time for two more, and I'm sure there are the two more questions in this room.
We can always just go home and wallow in our fear of the apocalypse.
Can you tell me how you think the hobby horse ruling may impact some of these cases and future cases?
The Hobby Lobby?
Yeah.
Well, so the Hobby Lobby decision from the 2016 term was a decision about the sort of whether closely held corporations could deny contraceptive coverage to employees, and the nature of sort of the religious, the religious exemption under the Religious Freedom Restoration Act of corporations. I don't think that Hobby Lobby itself doctrinally is going to dictate the outcome of the case now, the Masterpiece Cake Shop case necessarily. I think what we should be concerned about in general is the way in which Hobby Lobby opened the door to state-level laws, broadening religious exemptions, the way in which we are continuing, and there was a case subsequent to Hobby Lobby about just it being a burden on the exercise of religion to have to fill out the paperwork for the exemption, because basically under the Affordable Care Act, there's a contraceptive coverage mandate. Churches and other religious institutions were exempt and had to fill out paperwork for exemptions, and then basically Hobby Lobby opened the door for other types of closely held corporations to be exempt from that. And then people said that actually it was a burden on the exercise of the religion of the closely held corporations to even have to fill out the paperwork, seeking the one-page piece of paper, seeking the exemption, and then that was remanded in a very frustrating situation. What I will say is that what we should be paying close attention to, and what Hobby Lobby has opened the door to, is the continued assault on the ability to access reproductive health care, the ability of LGBT people to enter and engage in public space, and that this is a very well-funded, coordinated attack that is having success in the courts, that is having success in the state legislatures. It's hard to talk about, it's confusing, but I think what we need to be aware of is that it is ongoing, and it's both the big fancy cases at the Supreme Court, but going back to the state legislatures, it's in the states where these laws are being passed left and right. And I think the next thing to pay attention to that we have seen both in Congress and in many states are these First Amendment Defense Acts, which are laws that try to authorize discrimination based on sincerely held religious and moral beliefs, and they're now adding 3 types of beliefs. 1, that marriage is only between a man and a woman. 2, that the only type of sex that is sex between a man and a woman inside of marriage, and that trans people don't exist, basically explain that sex is the biologically determined sex that you're assigned at birth, which is opening the door to a whole range of types of discrimination, and the places where it's going to be the most painful for the LGBT communities are in the context of places like foster care agencies, social services, homeless shelters. The most vulnerable among us are gonna experience the most harm, and these are confusing laws, and it's part of a larger strategy. And I think we should always be looking behind what we're seeing in the courts and legislatures about who's funding it, what are their goals, who are they trying to eradicate, and this is true especially in this moment of we have bona fide white supremacists running our government. We have efforts to consolidate power in very particular ways, and there are long-term goals that these folks have, and we have to stay vigilant and be mindful of our defensive strategies against those goals, but also our affirmative strategies to retain a vision of liberation for ourselves and not just always be responding to them. And so just one quick pitch too, we've really, and then going back to Congress, and we have obviously been very caught up at the tax bill, but we're also getting close, to the need to pass a spending bill, and we need to pressure Democrats on a DREAM Act and a Clean DREAM Act, because it's, talk about an issue that impacts so many people, so many LGBTQ young people, that, March 5th is not the deadline. People's DACA is expiring every day. So this is a movement led by so many LGBTQ people, and our movement really has to show up. And we need to pressure Senator Schumer especially to ensure that nobody's going home for the holidays without a clean DREAM Act. And if the government has to stay open, to the tune of billions of dollars a day, then that's what's going to happen. So people should definitely be following that. There's the Supreme Court case. It's being argued tomorrow, and then there's a huge rally in D.C. on the 6th, which is Wednesday, about the DREAM Act and a clean DREAM Act.
So the message is, don't be depressed, fight back.
Yes.
Thank you all for coming, and thank Chase for a fantastic presentation.
Thank